Hello, it's my pleasure to introduce Judge Jose R. Rodriguez. Judge Rodriguez started working as an associate for Ackerman Centerfit back in the 70s before going to Tupperware in the corporate headquarters located in Osceola County. He became a prosecutor for the Ninth Judicial Circuit in 1978, and then in 1987, he was appointed as a county judge, then in 1993, appointed as a circuit judge. Judge Rodriguez rotated into almost every division in both county and circuit court during his tenure. He told an interviewer that the probate, guardianship, and mental health division was probably one of his favorite areas because the range of folks that you deal with and the fact that you get a sense of not just accomplishment, but of assisting others and those folks that are vulnerable and that need someone to sit and to have the patience and the time to spend and to value who they are. Judge Rodriguez is also credited with starting the first fully operational drug court in the Ninth Circuit on August 1st, 1997. He said it was very difficult because nobody wanted to do it. Then someone came up to him and said, Judge Rodriguez, we think you have the personality to deal with these kids. And they were right, he did. He relates that it was a single most in-depth experience in learning about child behavior and family dynamics. And that's just a little bit of Judge Rodriguez's background. Please enjoy the presentation on conservatorships in Florida, ? Thank you.
So thanks to Britney Spears, we all wound up wondering, what about conservatorships in Florida? Could that happen to me? Could that happen to my kids? Do my kids want to know what's going to happen to them if there is a conservatorship in Florida? Well, California is radically different than Florida. Conservatorships in Florida are very limited. They're a type of guardianship. And of course, as with all guardianships, we've got to look at less restrictive alternatives. There are a number of less restrictive alternatives in Florida. Conservatorships are not used very frequently. The conservatorships, the who, what, when, why, and how of conservatorships in Florida are specifically tied to a group, not the famous, not the singers, but in Florida, a conservatorship is appropriate for absentees. Wait a minute, absentees? You're going to this class and you're here. I hope you're not an absentee. But if you were an absentee, Florida 747.01 of the Florida statutes defines who you are. And here's who you are: an absentee person. If you're a person in the armed forces that's serving, person in the merchant marine, a person working with the Red Cross, again, those are statutorily defined by 741.01, subsection 1. Next, who else qualifies as an absentee? Well, let's take a look at when. When does an absentee qualify? Well, during any period of time when there are hostilities existing between the United States and any other power for a year or more. Someone who has been reported or is listed as missing in action, that's pretty much of an absentee, or interned in a neutral country. We call that a hostage taking nowadays. Someone who is interned in a neutral country, beleaguered, besieged, or captured by the enemy. Wonderful words to basically say, you're in a heap of trouble and you're not here, so you're an absentee for us. An absentee is considered legally an incompetent person, actually an incapacitated person. Incompetent is more a word that is used in criminal proceedings, incapacity more in guardianship issues. But the statute basically wasn't written by people that practice guardianship law on a regular basis, so they used the term incompetent when they meant incapacitated. And that, again, is someone that for the purposes of Section 4, subsection C, Article 10 of the state constitution, that's what again, an absentee is all about. An absentee also is if it's the owner or spouse of an incapacitated or incompetent person. The method of alienation, nothing out of a UFO, even though these days UFOs are, real. Nothing, the method of alienation or encumbrance shall be as provided by law. In other words, if you're going to sell, buy, in any way, shape, or form, transfer property or get out a mortgage, which is an encumbrance, this statute basically says that a conservator has to follow the law in those cases. Wouldn't it have been simple to say, just follow the law? But nope, we have to be very specific. Alienation and encumbrance has to be as provided by law. The sale, the transfer, or the mortgaging, or satisfaction of a mortgage has to be according to the law. Jurisdiction. That, to me, one of the things, when you first go to law school, or you take any kind of paralegal course, they'll talk about jurisdiction here, jurisdiction there, jurisdiction everywhere, to mean something as simple as jurisdiction is the power that the court has to decide the case. And in this case, in cases of conservatorships, the circuit court has exclusive jurisdiction to appoint a conservator of an absentee over the estate of an absentee. Next, how is jurisdiction acquired? How does the court get the power to basically appoint a conservator? Well, there has to be an interest in Florida property, or being a legal resident of the state. Makes you think, wait a minute, if you're a resident, are you really necessarily an absentee? Or wait a minute, what's this all about? Well, you can reside somewhere and not be in that place. For example, you can be a resident of, say, Kissimmee, but you are basically assigned to a reserve group that's being deployed somewhere else. And that's why the residence of that individual is Kissimmee, not Timbuktu or Timbuk3. The person also has to meet the definition of absentee in Chapter 747, which we earlier discussed. The spouse of next or not next door kin, but next of kin of the absentee who's a legal resident and no one has a valid power of attorney or any other document authorizing an agent. See, statute basically gives you a hint that a power of attorney, a durable power of attorney, because again, the durable power of attorney lasts beyond incapacity or incompetence. A power of attorney that is valid is sufficient to be a less restrictive alternative than a conservatorship, because a conservatorship deposits the rights to act on someone. A power of attorney does the same thing, and it's the individual who now is an absentee who's, again, entering into that valid power of attorney agency with the person that's being given the power to act. Another thing, too, is that, again, you see the big, conjunctive and. Not only do you have to be the spouse next to kin of the absentee who's a legal resident, and there's no power of attorney, but also there has to be demonstrated a need for providing care for the property, the estate of the absentee, judgments against the absentee spouse, children, parents, or the absentee. Well, how does that come up? Well, if you can't pay the rent and the bank is coming into foreclosure, it may be the conservator that has to take over dealing with those issues. In addition, anything that deals with taking care of the property, like for example, it needs a new roof, or it needs something less big, big or less, than an entire roof being changed, well, then it's up to the conservator to basically change that. In a way, if you're hearing shades of property, 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 guardian of the property, that's true. That's true. But in a guardian of the property, you have to have the absentee present under 744.331 to file a motion for incapacity, get the individual determined to be incapacity as it applies to not being able to handle. And in this case, the conservatorship helps because the person is an absentee and you can't make the determination of incapacity by a three-person committee because by statute you already have a presumption of incompetence, which translates to incapacity in Guardianese. See, you're learning a new language, Guardianese. How does this happen? How do you get a conservator established? Well, you file a petition with an absentee, and this is how you do it. You have to be an interested party. You have to have an interest. There has to be the absentee, obviously, and other folks that may have title or that may have a joint interest in the property may file it. There must be an interest in the property or the estate, and someone who was a dependent of the absentee, a child, a spouse, grandchild, whatever, a dependent of the absentee for maintenance or support is somebody who would be able to file, and again, by filing a petition. But those three questions are necessary: that the person is an interested party, that the person has an interest in the property or the estate, and that is somebody who's dependent for support. So now that we know you have to be an interested party, have an interest in the property or the estate, and be someone who is dependent on the absentee for maintenance and support, we need to continue. And we need to determine what actually is required in the petition. Now, one of the things that's important is that petition needs to be sworn, which means the lawyer, if there's a lawyer preparing it, generally, that lawyer has to swear to the petition to the truth and veracity. And again, every due diligence must be exercised. The names, addresses, the obvious names, addresses, ages of the spouse, the children, the mother, the father, the brothers, the sisters, or if none of these are living, then the next of kin of the absentee. In other words, family, however family is defined. The names, addresses of and ages of any other one would have an interest in the property of the estate of the absentee, where if the absentee were deceased, needs to be indicated in the petition. Now, the definition of an interested party is something that I hammer in and drum into my students. And that is the definition. You can find it in the statutes, but it's also part of case law. And the definition of an interested party appears here as any person who may be reasonably expected to be affected by the outcome of the particular proceeding involved. Okay, let's hear that again. Anybody, any person who may be reasonably expected to be affected by the outcome of a particular proceeding involved. Anyone who might inherit, or anyone who may be left out of a will is also somebody that needs to be notified. Because if that will is deemed to be invalid, that person is an interested party. So exactly, what else is required in a petition? The circumstances which caused the person to be missing, including the date the person was determined missing. You can look at the missing persons report if the person is someone who might be subject to foul play. The necessity for establishing a conservatorship. For example, the properties need maintenance. They need to be cared for. Whether or not the alleged person, the person alleged to be an absentee, has a will. and where you can find that will. Usually, if they have a will, folks have made sure that it's on deposit with the clerk of court. Of course, sometimes not. But again, that's one good first place to check. A statement of all property constituting an asset of the alleged absentee's estate and appropriate or approximate value of the property. What type of notice is to be given? Okay, here's tricky. Tricky, because we're dealing with the rules of probate. Okay, what type of notice is given? Under Rule 5.040, which is formal notice, all you need to do is you need to send by registered mail, by FedEx, by UPS, something notifying a copy of the notice in notifying the individual who will sign, so that, again, if there is a receipt that you can file with the court that the document that was served was in fact received, that's good notice under 5.040. Later on, after the initial filing, that's called formal notice under the probate code. Informal notice basically can be done by hand service, by the attorney handing the document to an interested person, or posting it if there's no one available at home, or leaving it at home with anyone over 15. The typical rules. A certificate of service that is attached to the motion, showing when the by hand, by mail, whatever, the document was served or sent to the individual, serves as prima facie proof of notice. Prima facie proof means at first blush. There's got to be, if somebody challenges it, there's got to be testimony as to how, in fact, it was handled. What does the court do then? Well, the court holds a hearing. That's what the court's in the business of doing, right? Holding hearings. So they've got to determine whether the absentee meets the statutory definition. Is this person an absentee, or is this person not an absentee? Is he missing or just hiding out? Let's talk about hiding out. Depending on how the person is hiding out, it may be that the person is subject to a conservatorship if the person cannot be located. The court must also determine whom to name as a conservator. The court may appoint a guardian ad litem to represent the best interest of the alleged absentee. Any next of kin or proper person who is fit is qualified to serve can be qualified to serve as a conservator. Conservator has to take an oath that he or she will faithfully perform the duties of the conservator and render true accounts whenever required according to the law. Post a bond so that if anything happens to the property, the bond may answer for it. Now, render true accounts when required by law. What does that mean? It goes back to chapter 744 and all of the requirements of filing the annual reports, of filing the initial plan, everything that needs to be filed, except, of course, there is no requirement for a physician's report to be filed because you've got somebody that's an absentee. But that you have to file with the court all of the reports that would have been required in a guardianship. See, this is why I don't understand why California conservators aren't as tight as we have guardianship in Florida and the requirements of reporting. Because I think with the requirements of reporting, there is a level of accountability that Florida provides anyone and everyone in the guardianship, or in this case, in a conservatorship. So what powers does a conservator have? Da-da-da, go into the phone booth. Boom, here goes super conservator. Well, really, it's all the same powers of a guardian of the property. So remember what I just told you a little bit about all the travail, the keeping of records, all of that's reporting to the court, issuing, keeping receipts, making sure that the court has them when they want them. Well, that brings us back to planet Earth in chapter 74 with all those requirements. And the absentee dependents are entitled to the benefits accruing to the ward. What does that mean? Well, wards are guardians. Let's begin with guardians. Guardians are required to visit their wards at least 4 times every quarter, once every quarter. Professional guardians, that is. So I guess the conservator has to visit if they're held technically to that. They are entitled to receive records, to receive copies of every single document that is filed, because also they're interested parties likely to be affected by the proceedings. Simple as that. Chapter 74. And if you take a copy of this PowerPoint, the benefits accruing to the ward are laid out in 747.035. Or again, check out chapter 744 that lays out the rights and the duties, the rights and duties of a guardian of the property, as well as the rights of the ward. So what happens when a conservator resigns or is removed? Well, it's time to get a new conservator or close the case. To have a new one appointed by the court, if under 746, all of the provisions regarding to guardians of property are followed. What does that mean? It means that there's a requirement of an education component. There's a requirement actually to have a lawyer. There's a requirement to file, again, all of the documents that are necessary, like the initial plan, annual plan, accounting. The conservator also has to have a level 2 clearance criminal background check, also a credit history run for the court to determine whether or not this person qualifies as a conservator. And by the way, at the beginning, these are also requirements of a conservator at first that is appointed. Okay? Not only is the new one subject to that, but the first one was subject to that. I didn't mention it at the beginning. To terminate a conservatorship, there needs to be a petition of the absentee. Petition of the agent under the power of attorney, or court orders of termination, property being transferred to the absentee or other power of attorney agent. So those are ways to terminate a conservatorship. What happens when an absentee dies and personal representative or executor is appointed? It's time for the court at that point to terminate the conservatorship. The conservatorship, just like a guardianship, only lasts while the individual, the absentee, or the ward are alive. The court enters an order terminating the conservatorship and orders then that the property be transferred to the personal representative or executor. Now, here's what happens. When the need for a conservator ends, say the person has passed away, the conservator is required to file a final return, an application, or a petition for discharge. And then the process, as I've been saying, follows the same notice and service of objections on interested parties that follows for annual reports. If there are no objections, or if objections are abandoned, or judicially resolved after a hearing, an order of discharge is entered. Let me repeat that. The process follows the same regarding notice and service of objections on interested parties. If you object to a discharge for any reason, whether fees haven't been paid or whatever the reason, objections need to be filed or need to be served on interested parties as required. If there are no objections or objections are abandoned, in other words, somebody enters an objection, then doesn't bother to set it for a hearing, or the judge basically says, I'm sorry, your objection is beyond the 60 days required for objections to be made. Therefore, the objection is null and void, and the court dismisses the objection. The order of discharge is entered. A discharge, yellow, okay? A discharge operates as a release of further conservative obligations and bars any suits. In other words, you get immunity from lawsuits for liability unless lawsuits are commenced against the conservator within 1 year from the date of the entry of discharge. So you've got 1 year after the discharge, and then you can go, phew, I'm out of I'm out of this because there is a 1 year statute of limitations. Again, to put it in simple terms. What happens when the need for a conservator arises, and the need is to sell real estate belonging to the absentee? Well, there's a summary process, and guidance can be provided by designing and including within the text of the statute a petition for summary procedure to sell or transfer the property of the absentee. Okay? In other words, check Florida statutes, because within the statutes, there's a summary process. It provides guidance how to sell or transfer the property of the absentee. If the property is of a value of $5,000 or less, a conservatorship need not be established. Given the value of the property, the application may be made without benefit of counsel using the statutorily prescribed form. In other words, you got a piece of property that's $5,000 or less. If you look in the statute, follow the application, follow the form that's prescribed in the statute, and you do not need an attorney to go ahead and file that. So, you see, conservatorships are a different breed. They don't sing, they don't dance. They're a less restrictive alternative, but again, it's when you have an absentee that you can't get in town to have a petition for incapacity determined. Again, the incapacity in an absentee is a matter of statutory construct, and it's the law. So I hope this has been instructive. One of the things that I will leave you with is that I looked and I looked and I looked and I looked through the Florida rules of probate, and there is no specific rule for a conservator, meaning that it was intended that the rules of probate for guardianship, as well as the rules of probate, or as well as the statutes in 744, be followed for conservatorships. There is a rule that deals with curators, but curators are individuals that may be appointed by the court after the proceedings to administer a will has started, and the letters of administration have not yet been issued. So that's the difference. A curator is not a conservator, is not a guardian, is not a guardian advocate.